So I'll read the allegations against you. You'll for a plea of guilty or not guilty. Your case has been assigned to Mr. Freeman. He'll be leading the interview with you. Then we'll hear from your wife, and if you'd like to speak, make a statement at the end, we'll allow you to do so. Okay?
Yes, ma'am.
All right, so we're here for a revocation hearing because you're accused of violating the conditions of your parole, specifically condition number 4. You were arrested by the St. Tammany Parish Sheriff's Office, charged with domestic abuse battery. You were found guilty of domestic abuse battery and were sentenced to 3 months in the parish jail with credit for time served. How do you plead, sir? Guilty or not guilty?
Should they plead me on, if found me guilty, I should, well, not guilty.
So wait, I just need you to tell me, guilty or not guilty. We can discuss it after you plea.
Guilty, man. They found me guilty.
Okay. Condition number 10, you're currently in arrears on your fees, $1,325. How do you plead, guilty or not guilty?
Guilty, man.
Would you answer Mr. Freeman's question?
Okay, Mr. Bennett, bring me back and tell me exactly what happened on that date when you were charged with this domestic abuse matter.
Me and my wife, we had a misunderstanding on sir. I told her I was about to leave and go on like to New Orleans. She didn't want me to leave because she didn't want me in that environment out there. She took me out to live out here, live a better life. And I didn't want to stay. I had to come here to get on my own, get my mind together to find out what I gotta do next time when I get out here, man. Sure.
Okay, was there a struggle between you and your wife?
Yes, she was grabbing me and I just pulled away from her.
Okay, did you hit your wife?
No, sir.
How did she get her busted lip?
I jacked away from her, so she fell down the steps.
At your trial, did your wife try to testify on your behalf?
And so she had filed the affidavit, so explaining to the judge and the DA what went on. Then I pursued the affidavits in court. When I went to trial. And my lawyer told her she ain't had to show up in court.
Okay, were you using heroin at the time this happened?
Yes, sir.
Okay, how often were you using heroin back when this happened?
Every blue moon, sir.
Sir?
Every blue moon.
Every blue moon?
Yes, sir.
So you wasn't using it all the time, you were just using it when every now and then, is what you're saying?
Yes, sir.
Were you using any other drugs on a daily basis?
No, sir.
Were you working at the time of these events?
No, sir.
Have you ever attempted to pay any of your supervision fees?
Yes, sir. Now, since I laid up there and sitting here and went cold turkey out and drugs and everything, I know what I gotta go out there to do now, sir. Stand up for my responsibilities, sir.
All right, so you just said you went cold turkey off the drugs. So
Sure.
were you using drugs?
I really ain't want to go to no rehab. Going to rehab, they ain't gonna do nothing but set me back for failure. They're gonna give you all kind of drugs in there anyway. Gonna make you go back out there and want to use more drugs.
Okay. That's all the questions, right?
All right, at this time, we'd like to hear from your wife, Ms. Kendra Bennett. Go ahead, ma'am.
Okay. What he's saying is exactly right. I was trying to keep him home and keep him out the street. And when he jerked away, I fell down the steps and busted my lip. But his presence is greatly missed. You don't know what positive aspects a person brings to you until you miss them. He made sure that the children went to school. He always gave a positive a positive motivation by using his life as an example of what not to do. telling them don't do this and don't do that. So, I just hate that all of this happened, and I think it could have been resolved in a different way. I overreacted to the situation, and I just really wanted him out of the street. I didn't want him going back to the West Bank at all.
Mr. Marabella has a question.
Ms. Bennett, why didn't you go to trial and testify for your husband?
He asked me not to go, really, so I didn't go.
That's kind of what I figured. I heard him say his lawyer told you didn't have to go. So,
Right.
Thanks. Okay.
I didn't have a problem going though, but it was just like,
I understand. They didn't want you to go.
Mhm.
Right. Okay.
All right, Mr. Bennett, is there a statement you'd like to make to us before we vote?
No, ma'am. Thank y'all for y'all time and thank y'all coming to see me.
All right, we're prepared to vote, and we'll start with Mr. Freeman.
Mr. Bennett, you owned heroin when you committed this offense. You were found guilty. You didn't plead guilty, you were found guilty. So my vote is to revoke your parole.
Mr. Bennett, my vote is the same for the very same reasons. Good luck to you.
And Mr. Bennett, I do agree with my colleagues. You pled guilty to violating those two conditions. My vote today is to revoke your parole. Good luck to you, sir. That concludes our business at St. Tammany. We'll adjourn at 9:34 a.m.
Yeah, we see this all the time, just all the time for these revocation hearings where the spouse, the girlfriend says, "Oh, I made it all up," or whatever. And it's frustrating because there, in my opinion, should be some type of punishment if the spouse does not follow through. I'm not saying send her to jail. I'm just saying that there should be consequences to the actions if you change your mind, which is just. And the consequences that I think would be that I think could be fair and play into the whole idea of making money in Louisiana from programs, but it would be to attend DV, if you're the victim or survivor program. So you would be in a room with other women who have suffered. And the idea is that now that you have to go and spend a month taking programs, hopefully you can learn something from it. And then also there are consequences. Hey, if you start finding yourself making the decision, you know what, I really don't want to attend all those programs. Maybe I'll just tell the truth. Maybe that can have a difference. I don't know. But we'll go through. I mean, he has a violent history, and we'll go through some of his records. He was wanted for attempted homicide. It seems that the charges were dropped. There was a mistrial. He was serving prison for other things. He received new charges while serving prison for attacking a correctional officer. We'll go over that. But also, he did get out on parole or just on good time, and was jailed really just a few months ago, October 16, 2023, for thank you, Richard, for sharing the info. I'm not sure what he was jailed for, but he's locked up again. And I think it might have been another battery charge, but I'm not 100% sure. Now, here is the charge for attacking a correctional officer. So November 25th, 2008, he was charged with 3 counts of battery on a correctional officer while incarcerated. He proceeded to trial on September 15th with a 6-person jury found defendant guilty as charged in all 3 counts. Can you imagine going to trial and thinking you'll win? I mean, your word against a correctional officer's word. The trial court sentenced the defendant to 1 year imprisonment of hard labor without the benefit of parole, probation, or sentence on each of the 3 counts in order to serve them consecutively. So he earned himself 3 additional years for that. Thereafter, the state filed multiple offender bill. Okay, they really went after him, alleging the defendant to be a fourth felony offender on the basis. I mean, if you're going to attack a correctional office, a corrections officer in prison, you know you have it coming to you. After hearing, the trial court found the state proved only 2 predicate felony convictions within a 10-year cleansing period of the defendant's underlying conviction on count 1. The trial court vacated the defendant's sentence on count 1 and resentenced the defendant, a 3rd felony offender, on count 1 to 10 years imprisonment and hard labor without benefit of probation and suspension of sentence to be served concurrently with the consecutive sentences order as to count 2 and 3. Facts. On September 6th, 2008, the defendant was an inmate in the custody of the Jefferson Parish Center. At approximately 2:40 p.m., Deputy Justin Reams, who was assigned, responded to a call involving an altercation between the defendant and another inmate in Pod 3B. When he arrived, the inmates had already separated. Deputy Reams noted the defendant was heated and agitated. He escorted the defendant out of the pod and placed him against a wall in the hallway to handcuff him. The defendant resisted efforts to be handcuffed by moving his hands and head wildly and erratically. Deputy Seymour saw Deputy Reams struggling to handcuff the defendant, and she assisted. A third deputy, Deputy Sean Williams, also assisted in gaining control of the defendant and handcuffing him. After the defendant was handcuffed, Deputy Reams, Seymour, and Williams escorted him to an elevator to take him to the medical area for treatment. While waiting for the elevator, the defendant continued to be physically combative. He struck Deputy Seymour in the upper chest and shoulder with his elbows several times. He was also verbally abusive and spit blood, which came from a small cut on the inside of his lip. You know, that's got to be one of the most terrifying things for me, and to be, if I was a correctional officer, is the idea that spitting blood and throwing fluids, which you hear is a common thing, and it's like just the fear that would cause. Oh, look, they talk about that. On the inside of his lip, all 3 deputies' faces and bodies, while yelling he would kill them. According to the deputies, defendant said he had used drugs when he was on the streets. He hoped he had AIDS. He hoped that the deputies died. The deputies managed to get the defendant to the nurse, but he was so combative to be immediately seen. And then, you know, you have to go and get tested, and you have to be nervous and you be stressed. And I do not know. COs, I got to tell you, and I heard COs in California, I think, get starting at like $100K a year or something. So like they're trying to, but I heard that still, and again, I haven't done research on it, so don't take what I say for anything. But I heard that they don't have any, that it still hasn't solved the problems with COs smuggling things in and whatnot. But in Louisiana, they get paid, I think, $12 or $13 an hour, and it's hard, unforgiving work, and it's not like no one calls you a hero on the outside, right? You're not appreciated. It's got to be one of the harder jobs. In defendant's first assignment of error, he argues the trial court erred in ordering him to be shackled during trial. He contends the trial court abused its discretion in shackling him because there was no specific justification for restraining him. I would say being shackled in a jury trial sounds kind of sketchy to me. He maintains he was prejudiced by being shackled because he's unable to take notes during the trial and could not stand when the jury entered or exited the courtroom. Defendant contends the restraint served no purpose but to influence the jury to think he was so dangerous he must have committed the charged crimes. I don't disagree with any of that. Prior to the commitment of the trial judge ordered that the defendant be shackled. He specifically noted that he was doing so because he was concerned with the health of the defendant's appointed counsel. We did have a case that we covered where and if you haven't seen it, I can try to remember to put the link in here in the description, where someone did punch his counsel. We covered that case, and he received something like 20 or 30 years for that. And 20 years later at his parole hearing, so maybe it was 30 years or maybe a life sentence. I think they actually gave him life as an habitual offender. And that attorney that he hit showed up at his parole hearing 20 years later to tell the parole board not to release him. I thought that was one of the I'll put the link here if you haven't seen it. It's worth seeing. Defense counsel objected and the trial judge responded. Mr. Bennett has a history in this courtroom of having had confrontation with officers in the past. He created questions in my bailiff's mind yesterday when he wasn't shackled as the safety of the courtroom. As such, the court has made a decision based upon the alleged prior bad acts that is a manslaughter charge and the activity in the case, and both as to charges to his acting out in the courtroom before, and is going to overrule the objection, ordered that he be shackled. But it's my understanding the shackles do not create any noise because they are synthetic material. And it's my understanding if he keeps his hands down, no one will know that he is handcuffed. Okay. So basically the judge is saying no one would know. But still, not standing for the jury makes one think. Ordinary defendant before the court should not be shackled or handcuffed or garbed in any manner. Here's my argument. If your attorney is scared of you, then how can you expect that attorney to properly represent you? To me, the very statement or assumption that the attorney is in fear of his client would mean that he's not getting proper representation. And that should have been a right? Ordinarily, a defendant before the court should not be shackled or handcuffed or garbed in any manner, destructive presumption of his innocence and the dignity of impartiality of judicial proceedings. However, exceptional circumstances may require the trial court with its discretion to restrain the defendant for reasons of courtroom security in order for the defendant's past conduct reasonably justifies apprehension that he may attempt to escape, finding reversible error in this court resulting in clear prejudice. Although the defendant alleges he was prejudiced by his inability to stand when the jury entered the exit of the courtroom, we note that the defendant was not alone in remaining seated, as the record shows defense counsel also remained seated. Okay, well, there's that point. Further, we find the defendant was not prejudiced by his inability to take notes during his trial due to the shackles. The case was uncomplicated, involved only 4 state witnesses, and took only 1 day to present. Accordingly, the assignment of error lacks merit. Prior to the trial, defense counsel raised the issue of the admissibility of a statement made by the defendant regarding the crime evidence. The statement issued the defendant had been a drug user in the streets and that he hoped he had AIDS and said the deputies would die. Defense counsel argued that any reference to the defendant's prior drug use was inadmissible other crimes evidence. She further asserts that she did not receive notice of the state's intent to use crimes. The trial court found the statements demonstrated intent and ruled evidence admissible. I mean, frankly, I think he's lucky he only got 3 years. But maybe that's the maximum for this type of offense. They found it admissible. What is this? They're bringing up references. Yeah. I mean, this guy, he's really a career criminal and he's locked back up. And just like life in and out of prison. And it could give you appreciation for the inmates that really seem to manage to do well in prison and take programs. And this is a different kind of situation for sure. But there you have it. I'll put the links in the description. And if he does have a revocation hearing, it's not clear to me. But if he does come up, we will post it here. And with that, I'll let you go.